Because of the SEC's case against Ripple, a new trial has begun. This is a continuation of a class action lawsuit that was first filed in 2018. There was a lot of confusion, though, because of the jury trial. The legal position of some transactions and the Hoy test will be taken into account. It was good for Ripple to win the lawsuit. This has confused a lot of people who own XRP. People in the community were worried that Ripple might be seen as a security in California, but not in New York. Another lawyer has also said they don't agree with this point of view. A message from Brad Garlinghouse, CEO of Ripple and Stewart. Alderode, chief legal officer of Ripple, explains what they meant by what they said before. Ripple's legal position after the 2018 case, on the other hand, does not change. Because of the recent changes in the law, some people in the XRP community are worried about Ripple's legal position. According to a story from CoinDesk, a judge in California threw out part of Ripple's civil complaint against the company. The remaining parts of the securities case will now be tried. At the same time, XRP community member and lawyer Fred Rulli said that Ripple had won the Oakland class action case that is now going to trial. Rule says that in the district court case about the class action lawsuit about whether or not Ripple's security has been fixed, the court decided that it is up to the jury to decide if all three parts of the Hoy test have been met. If the client wins, the claim is probably going to be settled because the damages are so small, and there is a chance that the jury will find against them. There is still work to be done by the cryptocurrency community to get federal law passed. Right now, things are looking good for making Ripple a security in California, but not in New York. Give it a big thumbs up, hit the subscribe button, turn on notifications, and join our group before we start. This will tell you everything you need to know about XRP. At the end of the movie, it's emphasized how important it is to know everything about Ripple's legal situation and the ongoing court battles that involve the company. And finally, the legal situation of Ripple has been a worry for the XRP community, with worries being voiced about the corporation's legal standing. Ripple will always be a decentralized digital currency. In light of recent changes in the law, it is clear that the cryptocurrency industry needs to be kept under constant pressure to ensure that Ripple will remain a safe investment. Of course, this is also the reason why XRP should be put through the hypo test. It's possible that XRP will be a SEC in California, but not in New York, like the speaker says. Bradley Garlinghouse said in 2017 that he was long XRP, but at the time he was selling it. This is the reason why this is the case. The speaker agrees that these things can work together. Still, they have to be taken into account when figuring out if there were illegal deals involving securities. One more person in the XRP community, an attorney called Bill Morgan, said that the HIPPO test would only be used for sales of XRPAN and not for the token itself. Now that you know what's going on, things are clearer for people who own XRP. Following the speaker's research into social networking site X and talks with lawyers, the speaker came to the conclusion that XRP users have no real reason to be worried. Mark Fagel, who used to work as a lawyer for the Securities and Exchange Commission, said what he thought about what was going on. In the California case, an executive of Ripple is accused of securities fraud. He said that before the court could decide if XRP was offered as a security, it had to decide if the executive was guilty of fraud. Even if the finding doesn't affect other parts of the company, Ripple may decide not to sell XRP in this area if it gets a negative one. Avigel believes that even if the court did rule on some XRP transactions that should have been illegal, the decision would only be valid in that part of California. This is because it would only be valid in that part of California. It could be seen as unimportant. It is agreed by the speaker that the case in question is the California case, and that the SEC's different case in New York would have been able to stop XRP. The class action case, on the other hand, has already been thrown out. The only accusation that is still being considered is related to something Brad Garlinghouse said in 2017. It doesn't matter if certain activities have to be linked to XRP, they are still illegal. The speaker ends by saying that while there isn't a good reason for users of XRP to be worried, the current situation doesn't change what has already been decided and doesn't give people any more reason to be worried. Stephen Alderode, who is the chief legal officer of Ripple, and Brad Garlinghouse wrote an article about the judge's decision in the California case that was filed against Ripple as part of a class action. This is because the judge in Northern California didn't agree with the claims that Ripple sold XRP in a way that violated federal securities law. There is a state law claim going to court that is based on something that was said in 2017. In New York, the decision that XRP is not a security has not been changed. According to the claims, the plaintiff lost a couple hundred XRP. He did not buy XRP directly from Ripple, and he can't say for sure if he even heard the message before trading. It is thought that the plaintiff's claim that he was heavily long XRP when he actually only had a couple hundred XRP is both baseless and an attempt to make money. Since the plaintiff did not buy XRP from Ripple and only had a few hundred XRP with him at the time of the trade, it is not possible to say for sure if he heard the message before he traded. Cass was a great example of the trolls who tried to break the law in the US and twist people's words in order to get hundreds of millions of dollars in class action settlements. Nothing in the ruling changes or goes against the fact that XRP is not a security by itself. And Brad Garlinghouse keeps making it very clear that all of the class action claims that were part of the case were thrown out. The New York court's decision meant that none of the claims that Ripple had broken any federal securities laws by selling XRP were true. The only state law claim that will now be tried is the plaintiff's claim. The person in question did not buy XRP from Ripple directly. And he can't say for sure if he heard the comment before he traded or not. He also had only a few hundred XRP with him at the time of the deal. People who were trolling tried to use the US legal system and twist remarks to get hundreds of millions of dollars in class action settlements. This was a clear case of doing this. People who own XRP don't need to worry because the charges the SEC brought against Ripple are very different from the ones being brought here. It's not even close to what the Securities and Exchange Commission wanted to be done. Attorney Fred R. Apley wrote, which was interesting because XRP might not be a security in New York, but in California. But the asset itself is never thought of as a security, and cryptocurrencies and other digital assets are not even in the list of things that are called securities. From what Brad Garlinghouse and Stewart have said so far, it looks like there is nothing to worry about and everything is fine. The video is over. Thank them for commenting and liking the movie. It makes YouTube work better. Tell a lot of people about this movie to spread the word.